Welcome, everyone. My name is Barton Morris, principal attorney at the Cannabis Legal Group. We can be reached at cannabislegalgroup.com. We're a law firm in the state of Michigan that services companies interested in entering into and competing within the Michigan commercial cannabis industry.
Hey guys, I'm Charlie Alvacetti. I'm at Vicente Cedarburg. I run the corporate group here at the firm. We're a national law firm. We've got offices in Massachusetts, in Boston, Massachusetts, New York, New York, Denver, Colorado, Jacksonville, Florida, and Los Angeles. We focus on helping the cannabis industry, both marijuana and hemp, nationally. And I work on a lot of financings, which is what we're going to be talking about today.
And Vicente Cedarburg and Cannabis Legal Group also we have an off-council relationship with each other, much like partners, particularly in Michigan. We work very closely on all of our application matters and our corporate financing strategy and documentation matters. So we work really closely together, and that's why we're doing this webinar together.
Yeah, and just to add to that, and I think everyone will see as we do this webinar, when you're doing any kind of corporate transaction that involves a licensed marijuana business, and even if you're doing it with an ancillary marijuana business, it's really important to understand the marijuana regulations in all the jurisdictions in which you operate. So, and that means both state and local. So, if you're raising money for a marijuana company that has a Michigan license, whether or not it's got licenses in other states, you got to understand the Michigan marijuana regulations.
We want to welcome everyone. So if that's joined us so far, we have a pretty good turnout so far. And I wanted to note that we do have a poll that many of you have already answered. Are you currently licensed by the Michigan Marijuana Regulatory Agency? This will help us understand kind of where our attendees are at, and help everybody understand kind of at least just a basic understanding of people's progress. But I presume everybody is seeking to be, if they haven't already, are seeking to be licensed by the Marijuana Regulatory Agency.
Right, and I'm looking at it now, and it looks like it's 41% yes, 58% no. But I would just add, even if you're just anticipating getting a license, there are some nuances there that you should think about, particularly if you're submitting an application now and your ownership will change while that application is being processed. But we can sort of get into that as we go along in the webinar.
Yeah. All right, Charlie, you want to get started on, I guess, the topic?
Yeah, sure. I just gotta, all right, so it's introduction. Okay, the fundraising process. So, we've only got an hour here, and it can be pretty complicated raising capital. So I'll just sort of talk in terms, trying to hit the high level points here, particularly what I think the pain points can be for cannabis companies and what we've seen over the past 10 years in terms of the biggest challenges people face. And then, obviously I prepared these slides in advance of the Corona outbreak, which is, it doesn't change a lot of things, but it's gonna, to be frank with everyone, it's gonna add to the challenge of the process, which is sort of my first point here, which is that, fundraising in the cannabis industry is in a lot of ways just like fundraising in any other industry, except harder. So, whether you're raising equity for a tech company or for a marijuana company, a lot of the things are going to be the exact same in terms of structure, but you're going to just have that extra hurdle of, one, marijuana regulatory concerns, And two, we call them the can of curious, which is just there's a lot of investors, particularly if they've never made a cannabis investment before, where you'll find that they're very interested, they're very curious, but when it comes to actually closing the transaction and signing on the dotted line and wiring money, sometimes people get cold feet before closing. So that's kind of just my thought here is I like to tell people up front, just be prepared for what is sort of a very difficult process, because I think if you're mentally prepared for what's going to be the challenge ahead, I think it'll make things easier. And then the additional challenge here is just with the sort of the economic disruption caused by the corona pandemic, you may expect to see things become more challenging, but deals are still being done. But I would expect some pressure on valuation from investors as they try and understand what's happening in the economic environment. So then turning to
I was just going to add that, in particular in Michigan, there isn't a big track record. We see what happens in other established markets like in Colorado, and we certainly take from Colorado's markets and others what we can. But I definitely see people that are less risk averse, are less willing to get into. They want to be in the cannabis industry, but they just don't. There's no promises, there's no guarantees, things change, and just like you said, when it comes to actually signing over amount of money, especially a larger amount of money, there can be some hesitation.
Thank you. Yeah, but I think the good news is for Michigan operators is that I think there's a lot of interest in the Michigan market. It's new, it's sizable, there's a lot of opportunity, and I think that that's definitely sort of something in your favor. So
Absolutely.
yeah, so securities law disclaimer, right? So there, basically two ways of raising money. There's public financings and there's private financings, and just at a very high level, public financing is like an IPO. You register your shares with the SEC, and then you can sell to the public. We're not going to get into that too much here. This is more focused on private, early stage financings, but it doesn't impact who your investors are. A public company can invest in a private financing. The difference is that a private financing, the securities being offered for sale are not registered with the SEC. And those securities, it doesn't really matter if they're debt or equity. The SEC takes a pretty broad definition of what's considered, quote, a security. So if you just raise debt by selling notes to investors, that's also going to be considered a security. So you've got the same considerations that you would have with an equity financing. So what are those considerations? Well, every security sold in the United States needs to either be, one, registered with the SEC, or two, issued pursuant to a specified exemption from registration. We'll talk about this a little bit when we get to the securities filings, the Form D. But most offerings in the United States these days, there's a few different options, but most offerings are done under what's called Reg D, which is Rule 506. And there's sort of two flavors of that. There's 506B and 506C. 506B is a private offering, meaning that there's no general advertising to the public. And then there's a 506C, which you can do offerings to the public. So, you could put an ad on TV if you wanted to. You could put an ad in a newspaper under a 506C offering. But there's some additional requirements with a 506C offering, which include taking reasonable steps to confirm that your investors are accredited. And accreditation is just a sort of a financial standard your investors need to meet in order to invest. You can take money in some instances from unaccredited investors, but I strongly discourage it for a number of reasons, and we can circulate to the group a couple of articles I've written on this. But the real reason you want to avoid unaccredited investors is, well, I think there are two. One is disclosure. Under certain securities law exemptions, like 506B, if you're including unaccredited investors in your financing, you have to provide specific disclosures, and it can be very expensive and time consuming to put together those disclosures. And the second reason is, it's not a very high standard to be an accredited investor. And frankly, if you're not accredited, you probably don't have the financial wherewithal to withstand a loss of, $50,000. So you might lose in an investment. And upset investors are a great way to get yourself sued. So from both a practical and sort of legal standpoint, I strongly discourage taking unaccredited investors. There are ways around that we can discuss if helpful. But so that's kind of the securities law from 40,000 feet. But once we get to the practical aspects, okay, you've got a marijuana company in Michigan, you want to raise money. So I'll talk about kind of the big picture things you're going to want to think about. One, you're going to want to put together a presentation. And this is not so much legal, though you want to be careful about what you put in the deck or the presentation or the confidential information memorandum. It goes by a couple different names. But basically, it's sort of a teaser to get investors interested in investing in your company. And that is, it can be critical to getting people's interest because the people that invest in these companies tend to look at a lot of companies. And they tend to have a lot of stuff going on, particularly now. So, you have to convince someone why invest in my company? Why this specific company? And you have to be able to get their attention. So, we've seen, in my experience, it's a skill set getting someone to invest. Some people are really good at it. It's don't have a ton of time to get into it here, but I think people understand the value proposition of the marijuana industry. So I think a lot of what people need to be thinking about when they're putting together their decks is why this specific company? Do you have unique skills or backgrounds that are going to allow you to build a successful company? Because particularly after the first kind of, we'll call it the cannabis boom, which has obviously sort of come crashing down, I think people are looking a lot harder at management teams and trying to determine, who are the best operators out there. So I think you'll see a lot of pressure testing on that from investors. So, what's the next step? Got the deck and then someone's interested in investing. So, call this kind of the term sheet stage. And this is where you're kind of just coming up with the key terms, the most important terms for the transaction. And then, once you get these term sheets signed, then you'll start drafting the definitive documentation. But you generally don't draft those final docs first because that just takes time and money from you before you even know anyone's interested. So, when we're talking about the term sheet, I'm just going to skip ahead for 1 second here. So the types of financing. So when you're at this term sheet stage, this is where you're going to think about the different types of fundraising and the different ways you can structure your deal. And there's one good thing about sort of this is there's a bunch of articles out there. We've got some we can send you as well if you'd like about the different types of structuring an investment. And there's not really one right way to do it. And I always try and tell people that because you can put together the best kind of financing term sheet you think you can do. And then, you go out to the investors and there's always going to be one investor who says, your lawyer's an idiot. You should have done it this way. And, here there are different ways you can do it. No one way is going to be the only way to do it. I say that, the fundraising structure that works is the one that works for your investors and for you. That said, you typically see stuff in a number of different, formulaic ways, and there's sort of form documents out there that people use. And I always encourage people not to reinvent the wheel. One, it adds time and legal costs to the financing. And then two, it's going to scare off investors sometimes because people always want to come up with these kind of unique structures. And I say, you go out with a unique structure and the investor is going to say, hey, it looks like you don't know what you're doing. So that's why my advice is always stick to the basics, no need to reinvent the wheel. Just do what's been done before and put something in front of your investor that they'll say, oh, this looks normal, or their lawyer will tell them, oh, this is a very typical way of raising money. And then they can focus on your company and not trying to do the brain damage of how to figure out, how this particular financing works. So in terms of early stage financings, early stage companies, you basically see three different types of ways of doing it. One is a convertible note, which is basically a debt instrument that upon a later financing will convert into equity. And it's very similar to a SAFE, which is a simple agreement for future equity, though that technically the difference is the SAFE is not actually debt. So if you don't raise money in the future, you don't actually have to pay off the SAFE. Though in sort of practical reality, for a lot of startup companies, the debt is the debt of the company. And if the company's not able to raise future money, it's going to shut down anyhow. So it may not make a huge difference if it has debt or not, because the debt will sort of dissolve with the company. But basically, these are very simple documents, and it's sort of like an agreement. Hey, we'll figure out the complicated stuff later. And the equity terms, so the operating agreement or the shareholders agreement. But for now, we're just going to give you this money. It's got an interest rate, and usually the most important term is whatever discount it converts at. And then the third option, which is, can make sense in some cases, is a seed equity raise. And that's where you're actually selling equity at a company. Now, there are some form documents for seed equity raises, like there are for SAFEs and convertible notes. But it can be a little bit more timely and costly because you actually have to go through sort of the thought process of figuring out how to structure the equity. And then you get to these later stage financings, if people have heard of, Series A, Series B, Series C. So these are kind of, later ways of raising money. So go back to the term sheet here. Obviously, other than the structure, the other key term here is valuation. So valuation is, how much you're selling, how much saying your company is worth. And one of the advantages, just to skip back, of the convertible note or the SAFE is you don't have to set a valuation of the company because you're not actually selling equity of the company. You're only saying, in the future, if we sell equity, the debt will convert. So you're able to basically punt on the valuation to a certain extent. Sometimes people have what's called valuation caps in a note or a SAFE, which basically says, if the valuation is above a certain amount, the early stage investor converts at a lower valuation, so they get more of the company. But that's sort of a complexity. But the advantage of that is you don't have to say how much your company is worth, because it can be exceptionally difficult if you're pre-revenue to say how much your company is worth. I'm going to try and speed it up a little bit here because there's a lot of details here. So the other big one here is a lead or no lead. And that basically means, do you have a lead investor? So there are pros and cons of both paths, and sometimes you have to kind of pivot between them. I think in an ideal world, you have a lead investor who's going to come in for a big chunk of the money you're raising. You can negotiate your documents with that lead investor, and then everyone else, all the other sort of small investors, they don't have to get involved with the drafting of the documents. They sort of know that the lead investor has taken care of that, and they can sort of just look at the terms and give it a thumbs up or thumbs down. So that's the big advantage of having a lead, is that you don't have to negotiate with a crowd of people. You can sort of just pick one person and negotiating with them. The challenge is, particularly in a difficult fundraising environment, it can be difficult to find a lead investor. And you may also have, call it 10 people that are interested in investing, but no one wants to be the first. No one wants to be the lead because there's a risk, right? What if you put your money into this company and no one else does? You have a good chance of losing your money. So if you don't have a lead, you got to be strategic about it, because the risk is you bring in money from a few people and then the next person says, "Oh, why'd you do it this way? I want to do it another way." And then you basically kind of have to tweak what you've already done to accommodate the new people, and it can get really messy. So if you're going without a lead, which is something that you may have to do, um, you just want to think about that and think about how you're going to have to pivot down the road if people sort of object to the terms, because you don't want to have a situation where, you started raising money and you gave people these terms, and then you had to change the terms later on, and you've basically sold securities to two different groups of people at two very different terms, because that exposes you to a risk that someone could say, "Hey, these guys, you know, they kind of screwed me. I paid more than the earlier guy or the later guy, but I got the exact same thing." So it creates risk for the company. So you got to think about that. Um, so with that said, I kind of want to get Barton involved here. And so I'm going to talk about where you start thinking about the regulatory issues. So the first place the regulatory issues definitely come up is due diligence. So, it's a highly regulated company. So the first thing people are going to want to talk about is, your licenses. And you want to have all your stuff ready to go. So you basically have, you want to set up online, maybe in Dropbox. There are a couple of other different ways to do it. It doesn't really make a huge difference what you use. But the bottom line is you want to have all the documents investors are going to ask you for lined up in advance, because it'll make you look professional. And if there are any issues, you want to get ahead of them and discover them and clean them up in advance of the investors finding out about them, because that's going to look pretty bad. So with that said, I'll turn it over to Barton just to talk about, what you're going to want to have ready for your investors to show them either your Michigan licenses or your application for a Michigan license.
Thank you. We see in our application work that companies want to sometimes use the strategy to get licensed first and then go and add equity members to the application, because there's sometimes a risk if you don't do your due diligence, and let's say the lead investor or the core group of C-suite managerial, I guess, equity members, if they're asking for investors and these people come on and they don't do their due diligence, and then for whatever reason they are denied because of the documents that I'm about to, the disclosures that you have to provide, that puts the whole company in jeopardy. And that's when we often use these types of like convertible notes and safes in order to take in the money, because obviously some money is going to be necessary in order to get the license, but later on convert that to equity, because if we get the license and then we seek to get the marijuana regulatory agency's permission or approval to add an equity member, then you've already got the license. All they can do, and they usually will do, is say no. They're not going to go back and take your license. And so that's a very common strategy that's used. Get the license first and then add equity members and investors later. But the documents that are going to be necessary in order for that due diligence and for the marijuana regulatory agency are going to be primarily your financial documents. They want to see your finances, and they want to see your bank statements and your tax returns. They want to make sure that that somebody's not engaged in money laundering, because evidently they think that in the marijuana industry that's a prevalent circumstance. And what I've seen, it's not necessarily the case, because there's a lot of people in the marijuana industry, they're just coming in from other industries, and they're no more criminal than anybody else. But unfortunately, regulators seem to think that they have to make sure that people are not engaged in any unlawful activities, which I suppose it's okay. In addition, to, of course, criminal background, criminal history. Most of our clients generally don't have one. It's usually not that big of an issue, but that's something that can cause a denial. And then their regulatory oversight, governmental regulatory oversight, and whether an individual or a company has ever been involved in any type of compliance issues or non-compliance, whether they've been cited for non-compliance and any other regulatory licenses that they own, whether it be a liquor license or a financial license, a securities license, or um, um, other types of governmental licenses. They look at that stuff, and as investors, we have to look at that in our potential investors as well. As far as companies, we have to look at that in our potential investors as well. So, as far as due diligence, those are things that we're looking at. And then of course, I see a lot. It happens a lot. People they want to bring in investors, but they don't really do the due diligence necessary to ensure that the people that are coming in have the money that they say that they're going to have. So I think it's a good idea to look at proof of funds, and just don't assume that an investor has what they say they're going to have. Sometimes they think that they're going to be able to raise it, and they don't really have it themselves.
Yeah, that's a great point. Is due diligence in the cannabis industry goes both ways. I've seen a lot of deals where you get these people coming to the table saying, I want to look at your company. I want to invest in this round. And then only later does it come out that, they are a fund that has no limited partners, no LPs. They have no money. They're going to, say they want in on your deal, and then they're going to go out and reach out to their network of people and try and raise money. So that's definitely another kind of cannabis specific fundraising point, which is that you don't see that as much in other industries, which are, people looking to invest that don't actually have the money. They're just going to try and go out and raise it. But to kind of close the point on the due diligence thing that Barton was talking about, this is where we talk about, background checks. So this is the background check and the regulatory approval are sort of the two biggest challenges in cannabis financings versus regular raises. One is that you may need to get your investors background checked. So this is a very important thing to understand, before you go out and raise money. And in my experience, this has been the number one thing that blows deals up, which is the regulators ask the licensed business, you guys, we need this background information from these people on your cap table. You turn around, you go to the investor, and the investor says, no, I'm not giving that. I don't feel comfortable providing my fill in the blank to this regulator. So I think the way to handle this, and it's a very delicate conversation, is, one, talk with a guy like Barden up front in Michigan. Make sure you understand exactly what the regulators are going to ask for and when they're going to ask for it, so you can sort of communicate it up front to the investors. Obviously, this is more of an issue for people that have not made a cannabis investment before. I mean, if people have investments in, let's say Colorado or California, they're probably going to be used to the fact there's going to be some kind of background check, and it's not going to come as a total surprise. But I've seen this. I've seen this sort of basically put people's licenses at risk, because the regulators sometimes will demand these background checks sort of to renew a license, let's say, in some cases. So make sure you understand that up front. And then the second one, which we'll go back to the earlier slide talking about rolling closes versus non-rolling closes. But the other big issue for marijuana specific financings is sometimes you need pre-approval to bring in the money. And sometimes you don't. Sometimes you just need to provide information afterwards. So it's very important to understand, and in Michigan, I'll turn this over to Bart in a second, but there's a 10% threshold for pre-approval. So if you're worried about that messing up your raise, then one way around it is you make sure that no individual investor or investment group can invest 10% or more, right? So you have like a maximum investment amount, and then you can just sort of provide updates to the regulators afterwards. But the other sort of nuance, and in a lot of ways, Michigan's like California here, but you got to look at the localities as well and understand if there's going to be any kind of approval required from the localities, and see if you can structure around that. Because if you can structure around that, you should, because anything you can do to make it easier to bring in money is going to make your lives easier. So if you can limit people to say, 5% investment in your company to avoid the pre-approval, I strongly recommend you do that, because you'll be thankful you did. So with that, I'll turn back over to Barton to talk about, what kind of events of equity holders will need to get regulatory approval, and which ones just sort of like give notice after the fact. But bear in mind what I said about the background checks. Even if it's just a background check and there's no pre-approval, you got to make sure up front they're cool with it, because you don't want to hit them with that surprise and then be caught between the regulator asking for information on one hand and an investor denying it on the other. And the other thing I'll just say quickly here to contemplate adding to your investment docs is, what we've done in the past is you basically put in a requirement into the investment documents that the investors sort of comply with all the background checks. And you may also want to have some kind of provision to kick people out of your company if they either refuse to do a background check or they commit some sort of act that's going to make them inappropriate to be an owner of a licensed business. Because you don't want to run into a situation where you've got 10 people who invest in your company, one of them's a bad apple, gets convicted of something, and now the regulators say, hey, we're going to take your license because you've got an impermissible person on the cap table.
You made a good point about the localities requiring approval. Sometimes so the cities they operate differently. Some cities, they don't care that you've added new investors or hope to add new investors and have a new cap table. Others are very particular about the fact that they want to be controlling over exactly who gets a license. And you made this application saying that this is your team, and if you're going to materially change the team, someone will object to that. And if you don't find that out beforehand, then you could be in a situation where the city says, no, we're not going to permit it, and you're going to lose your license if you try to do it, or if you do it without our permission. Because some cities are like, look, we're only issuing 3 licenses, and we've got a list of 20 people that are applying, and if you are not going to honor your commitments of the application and of their ordinance, then they're going to move on to number 4, as opposed to permit some changes. And so that we've seen that already, and we have to get super creative with respect to getting other investors involved that weren't originally on the application. And then with the state, I think a good strategy oftentimes as well is that individuals can get pre-qualified just as easily as, or at least the application process, just as easily as a company. And so when an individual is pre-qualified, when the regulatory agency and the MRA, they already have that pre-qualification of that one individual, they will then easily become pre-qualified if they're a part of an entity application. So what I mean by that is, let's say an individual who is seeking to be an investor, they just get themselves pre-qualified, just not as a part of a corporation, but just themselves. And now they got this letter of pre-qualification, and the pre-qualification again is providing the regulatory agency with your financial records and your criminal history, and by the way, not just your criminal history, like your arrest history. Basically, any incident that you've ever been involved in, you have to disclose, because if they find out you haven't disclosed something, that's one of the highest rates for, or one of the highest reasons for denial. and your tax returns and real property. You gotta provide them with real property and your regulatory compliance history, and also civil litigation history. And then once an individual is pre-qualified, they're able to then kind of be a more qualified potential investor in a company because that company, if you're a company looking for an investor and somebody comes to you that's already been pre-qualified individually, then you know it's going to be easy. The marijuana regulatory agency is not going to deny that approval. They're always going to permit it. They really can't deny it as far as because you have to get approval when you're going to change your equity structure. You have to get their approval, and as the states, and that goes for anybody that's more than a 10% equity partner or equity shareholder. If it's less than 10%, then there is no disclosure requirements, nor is there any approval necessary. Although you do have to disclose those additional members or shareholders. They don't approval is not necessary, but anything in excess of 10% is necessary. So those are, I guess, just some quick advice with respect to making sure that all of these deals are getting the appropriate approval, both from the municipality and the MRA, and also recognizing that individuals can get pre-qualified, which can make things easier later on.
Yeah, and as long as we're on this slide, so touch here about alternative structures, which is, something we've seen a lot in other states. So,
Yeah.
if you're in a situation where the investors are saying, listen, no way, no how am I providing my information to the regulators, but I also want to own 20% of the company. So what you see in a lot of cases, and pretty common, is people set up an entity usually that owns the intellectual property of the company, and then they basically license it to the licensed business, which they may or may not control, or they sell packages to the licensed business. The goal is to be able to take some of the money being made by the licensed cannabis company and move it into this holding company. You saw a lot of holding companies set up in states where there were strict residency restrictions, Washington, Alaska, Colorado. And you also sort of saw these structures in states that had nonprofit systems in the past, so a Massachusetts or a California. So the big caveat here is you got to set it up in a way that works for regulatory purposes. You can't have agreement that says, my IP holding company controls all decisions of the licensed company. That's the one big no-no. You can't control the licensed company. The other big one is you can't take a direct percentage of revenue or profits. You can't have a licensing agreement that says I get 99% of the revenue of this licensed business. But there's a number of ways to set it up. So it's compliant with the rules, with the obvious caveat that you never really know what's going to happen in the future under these systems. But then you raise the money, your investors invest into the IP holding company. And then the IP holding company, maybe it lends the money to the licensed business or somehow supports the licensed business. Or in some cases, we've seen, particularly with brands where you're trying to come up with a national brand, and you may not actually want to own licenses in different states. You just find a licensed partner to work with and have them sort of produce the good for you in a compliant manner. And then that'll allow you to, build sort of a national brand without going through the expense or trouble of getting licenses in all these different states. So I've seen these work. And it can be another way to make it easier to bring in investors, because then you don't necessarily have to worry about getting pre-approval or background checks of your investors. Though, if you push the envelope too far, the regulators might start asking about who owns equity in this non-licensed holding company. So, take that with a grain of salt. That's the big risk there. So then, to kind of go back to the fundraising process, few other notes here, and then I think at the end we can kind of open it up for questions. is, closings. This is the other kind of big picture structural question is, do you raise all the money and close it all at once, or do you take in the money, as it comes in? And then the nuance there is sometimes you have a minimum raise as well, where you say, I'm raising $2 million, but I'm not going to take a dime until I've got $500,000 committed. And then I'll bring that all in at once. And investors like that because they feel, if I give you just a small amount of the money you need and you don't raise any additional money, then my money's basically gone, right? Because it's not going to be enough to make you profitable. So sometimes you have to agree to a minimum raise, and sometimes you'll put that money with an escrow agent. We're having success finding escrow agents who are willing to work with the cannabis industry now. It used to be a problem, but it's largely solved now. But that's kind of another big decision point is do you do a minimum raise? Do you do one close? Do you do multiple closings? In the financing world right now, in cannabis, certainly I would say rolling closings are kind of the norm. Just because it makes it easier and you get that money in the door. So that's a rolling close. And then a note here about securities filings. So if you're using what's called this Reg D offering, 506B or 506C, you have to file within 15 days of your first definitive commitment of money. You have to file with the Securities Exchange Commission, the SEC, what's called a Form D. Which basically sets out sort of the terms of very, very high level, but the amount of money you're trying to raise, how much you've raised to date, the specific securities exemption you're relying upon. And then in addition to the Form D, there's also this other sort of area of law, which is called blue sky law. Each state has their own securities rules. And if you do a Reg D offering, you then have sort of a notice requirement in every state where you have an investor and also your state, your principal state of business, to sort of disclose this Form D. So you also have to do these Form D, these blue sky filings in each state. And luckily it's now mostly online. There are a few states that still require paper filings, but you file the Form D and then you file the blue sky filing. So, if you're doing rolling closes, you might have to update your blue sky filings as you go along. But the big thing I like to warn people with the Form D filing is it's public information, and there are some of the more sophisticated journalists out there are aware of this. So sometimes you'll see, a news report, so-and-so's raising money, and you think, how do they know? Well, if you track these Form Ds, you can see who's trying to raise money. It's all on the SEC website. And what sometimes people feel uncomfortable with is, it says how much of the money you've raised. And because you're filing it, that's at the beginning of the fundraising process, you may not have really raised as much money as you hope to have raised. So it can sometimes people feel like it looks bad because they say, I'm trying to raise $2 million, but I filed this form that said I've raised $0. It kind of scares investors off. But that's just something to sort of be aware of. We talked about due diligence. Working with bankers. So, sometimes, and bankers tend to want to work on larger raises because it doesn't really make sense for them financially to do smaller raises. But sometimes people get, in this process, they're usually called placement agents, and they'll take basically a cut of the money you're raising if they can find you investors. And, it's not really an option for everyone because I think bankers will only sort of take on projects if they think they can be successful. But it is something to just be aware is out there. Now, to get to the targeting the right investors slide here, what are these placement agents going to do? Well, they've got a list that they've developed of, everyone who's interested in cannabis deals. If you sign up with them, they're going to take your deal and then shop it to, the people they think who will invest. So, before I open up for questions, I'll just talk kind of briefly here about who we see investing in the cannabis industry because it's important to target the right people. The big thing is, as everyone knows, marijuana remains federally illegal with very, very minor exceptions, which aren't going to apply to anyone on this call. So a lot of traditional investors won't touch the space. Sometimes people feel more comfortable, and I've seen these sort of tech companies, the investors, some of the sort of the venture capital money feels comfortable with these tech companies, particularly if they don't own a license, which might be another reason to explore that sort of packaging agreement concept. So, you know, your big names in cannabis tech, the Eases, the LeafLinks of the world, those guys have been successful in raising money from funds that probably wouldn't touch a licensed marijuana business in Michigan. So just be aware, you know, some people are just going to say no right off the bat because it's marijuana. Now, the money coming into the cannabis industry right now, we find it tends to be because, again, the funds can't do it because it's illegal. It's family offices and high net worth individuals. So family offices are kind of these wealthy, big name families. Some of them are not necessarily big names, but family offices will invest in the space. So that's a good sort of group of people to target. High net worth. High net worth is another option because, you know, again, individuals don't have the same sort of restrictions on what they can and can't invest in that funds do. And then the other one here, funds, there are some limited funds in the cannabis industry that you can reach out to. That's an option. And then fourth, you know, public companies. Now, unfortunately, with what's happened with the cannabis capital markets, the amount of capital that these companies have to spend has sort of been greatly reduced. But if you go back a year, 2 years, you know, a lot of the big deals, it was public companies, you know, investing, using their stock as consideration for acquisition. So, you know, hopefully, and the stocks have been up this week, but, you know, so hopefully they're able to raise more money in the future. But, you know, for the time being, it's probably not going to be as profitable. But, you know, these MSOs are another option, though they may be more interested in acquiring than just investing. And with that, I'll turn off for Barton to see if he has anything else to add. If not, we can sort of take some questions.
We don't have a lot of time. I think probably good. Any questions would be good right now.
So, seeing a question here from Susan: aren't individual investors limited to 10% in Michigan? I'll let Barton handle that one.
So no, that 10%, individual investors are not limited to 10%. The 10% rule that you're probably referring to is the threshold under which the regulatory agency will require disclosure. So anybody over 10% will necessitate disclosures being made, your tax returns and financial statements and property records, whereas anybody under 10% will not have to make those disclosures. Maybe you might be thinking about, sometimes people think that you have to be a Michigan resident in order to have more than 10% ownership of a company, and that's not true either. Although there are two specific license types that do necessitate Michigan residency, at least until the end of next year, and that would be for our recreational licenses, the grower license, 100 plant grower license, and also the 150 plant micro business license. But for the rest of the licenses, particularly the medical licenses, there is no residency requirement.
One kind of nuance here is, you know, for example, a lot of states have restrictions on owning a testing license and a non-testing license. So that's another thing you may want to put in your investment documents and make sure your investors haven't invested in a testing license if they're investing into your company, because that's another sort of background issue. Okay. Are there minimum amounts that are logical to raise? 500K, that's 1 million. So, you know, that's, you know, usually you see in these early stage financings that, you know, kind of the more sophisticated decks that you see at these, you know, pitch events and stuff. You know, I think people usually raise, you know, call it 500. I see a lot of 500, but I see more like a million, 1.5. I think the key is when you're thinking about the minimum amount to raise, is what's kind of the minimal viable amount that would allow you to get started and not just kind of pour the money without any result. Because I think that's what, if the investor drills down, that's what they're going to want to know, is that, if you take my money, is it going to be useful, or is it such a small amount that it's basically, wasted? So yeah, I see a lot. I see 500K a lot, but a lot of times in the investing space, frankly, people just put stuff out there because it's sort of typical. They may not necessarily think it through, but I think it's important to think through kind of from a just a purely business perspective, like what's the minimum that I could be useful with. Are there any sort of tax consequences based on investor approach? Right. So didn't have time to go through this slide, but the main tax consequence that I think of in the cannabis space is, because you're subject to 280E, there's some, you'll get different advice from different people, but from my perspective, I think there's a strong advantage to being a C corporation in the cannabis space, because, and the rules have changed a little bit around this, and it's pretty nuanced, but with an LLC, the profits flow directly to the owners of the LLC. And if you don't properly account for 280E, or if you're too aggressive on your 280E and you get audited, there can be some exposure to the equity holders of the LLC. So if you're a C Corp, you don't necessarily have to worry about that, because it's only sort of taxable to the shareholders if and when there's a dividend. Now, a lot of people think that they're going to be an LLC because the taxes are lower, because there's only one level of tax within LLC, where a C Corp is taxed 2 levels. It's taxed at the entity level, and then any distributions the investors are also taxed. So people think, oh, I'm going to be an LLC, I'll have lower taxes. But my experience has been, because this is a startup driven space, is that there's really not, once you sort of reinvest into operations, there's really not any extra cash to go around. So that, the concept of an LLC may not make as much sense for a startup as it does for, let's say, a real estate investment, where you're buying a building, and then, that you've got these steady rents that are just going to be cash flowing out to the investors. So that's kind of the big tax consequence that I've seen. And, also with the alternate IP holding company structure, there could be some tax inefficiencies there, depending on how it's set up.
I can add that, at least I know that you can be an LLC and be taxed as a C Corp, and so that you could avoid potential liability for 280E. But although we do generally make that recommendation as well, anybody, particularly retail licenses, we suggest that they set themselves up as a C Corp. And I agree that generally the double taxation is not an issue, because the corporation, especially in a startup industry, it's not like you're going to be making a lot of profit, for several years potentially. But also, we hope and we think that the federal policy is going to change with respect to cannabis, and 280E hopefully is not going to be an issue in 3 to 5 years. So, but I also would add that it's not a matter of when you get audited. It's a matter of, it's not a matter of if, it's a matter of when, that most cannabis businesses are going to be audited.
Yeah, and Steven, so C Corp versus S Corp. S Corps don't really make sense if you're raising capital, because there are restrictions on who can be the equity holders of an S Corp. It's called busting S Corp status. And if you've got basically entities as your shareholders of an S Corp, it may bust the S Corp status. Obviously, if it's a small business like a bakery, you can be an S Corp because it's just going to be individuals owning it. But when you start raising money from funds, that can create S Corp issues. And the other challenge with S Corp is you're limited to one class of equity with an S Corp. So if you try and issue preferred equity, that'll also bust the S Corp status. So if you want to be taxed as a flow-through entity, you really got to go as an LLC. It just doesn't work being an S corp if you're raising outside financing. Okay, I think we lost the sound here, so maybe we're wrapping up. But thanks everyone for joining today, and we'll follow up with some information that we hope is helpful. And we wish everyone the best of luck in these challenging times.